You see someone acting suspiciously. You believe they might be involved in a crime. Can police detain someone just to investigate? That question was addressed in R.V. Simpson. Before this case, Canadian law wasn't entirely clear about whether police could briefly detain someone without arresting in order to investigate a crime. In Simpson, the Ontario Court of Appeal recognized what is now known as investigative detention. The court held that police can briefly detain a person for investigative purposes if they have reasonable suspicion that the person is connected to a particular crime. Reasonable suspicion is a lower threshold than reasonable grounds to arrest, but it still requires objective, articulable facts. It cannot be based on a mere hunch. The detention must also be brief and focus on the investigation. Police cannot use investigative detention as a fishing expedition. The purpose must be to quickly confirm or dispel the officer's suspicion. Later Supreme Court cases expanded on this concept. For example, in R.V. Mann, the court confirmed that officers may conduct a limited, pat-down search during an investigative detention if there are reasonable safety concerns. And in R.V. Clayton, the court confirmed that investigative detention may also occur in higher-risk situations when public safety is involved. Operationally, R.V. Simpson established the foundation for investigative detention in Canada. It allows police to briefly detain someone when they have reasonable suspicion that the person is connected to a specific crime, but that detention must remain limited, focused, and justified by the circumstances. This is not legal advice, just a briefing on Canadian case law.